Good afternoon, everyone, and thank you for attending today's clemency briefing. My name is Jeanne LoCicero, and I'm the legal director at the ACLU of New Jersey. This week has been full of amazing clemency news, with Governor Murphy granting 33 pardons and 3 commutations on Monday. And just like within the last couple of hours, the 3 women whose sentences were commuted were released from prison and into the arms of their loved ones. Earlier this year, the ACLU of New Jersey launched the Clemency Project to advocate for categorical clemency and represent clients seeking commutations. This was part of our larger vision to end mass incarceration in a way that centers racial and social justice. To reduce extreme sentences, we, along with many advocates and partners, had already been working in the legislature and the courts, and then, inspired by colleagues from the National ACLU's Redemption Campaign, we started to look at the executive branch. Categorical clemency allows a governor or president to examine holistic injustices that have impacted groups of people and consider relief for each person within that identified class. And it's an important check and balance on our criminal legal system. And it's just one tool that has existed since our nation's founding. You'll hear more about all of this from our esteemed experts shortly, but in the wake of Governor Murphy's historic executive order creating an expedited review process for certain categories of people, the ACLU started hearing from more people eligible for this review that we don't have more than we have the resources to represent. And we've been receiving calls from lawyers about how to best assist people with these petitions. So today's briefing is to provide details about the clemency process in New Jersey and hopefully inspire you to represent or support the many deserving people who may be eligible for expedited review. So with that, I'd like to introduce you to our panel. I'm going to keep this quick and recommend that you read about their deep expertise in the bios that are provided with the CLE materials. First, we have John Butler. He's the Director of Criminal Justice Policy for the Governor. We have Jessica Henry, who's a member of the Governor's Clemency Advisory Board. Lee Kelsey O'Donnell is Special Senior Counsel to the Governor. And Allison Perrone is Deputy Public Defender for the state of New Jersey. And I'm going to hand off the mic to my colleague, Rebecca Uwakwe, who is the director of our Clemency Project, and she will moderate today's discussion. So thank you again for attending. And Rebecca, it's all you.
Thank you so much, Jeanne. And I want to echo the gratitude. I want to really echo the gratitude to our and extend the gratitude to our partners and express my excitement to join this esteemed panel here and engage with all of you all who are passionate about understanding the clemency process and advocating for your clients. I am super giddy, super happy today because I just came from Edna Man. I just met our clients at the gate as they were released. So I am super thrilled to be here with you all today. So if I'm just smiling, if there's just a smile on my face, it's just stuck there. Now you know why. I'm really excited about this process. And special thanks to Lowenstein and Sandler for their generous support for this event and for providing CLE accreditation. So if you want to receive CLE credits, it is going to be 1.5 credits for this training. And you would just need to fill out a survey at the end. So there are forms, just check out the links at the bottom of this chat. And I will also be announcing 3 CLE codes during the presentation. So look out for that, okay? So we're going to jump right in. All right, so I'm gonna start with Lee Kelsey. So can you explain the scope of the governor's clemency power in New Jersey? Can you tell us, are there any limitations to the power?
Sure. Thank you, Rebecca, and thanks to everyone here today, including my colleagues on the panel and for ACLU and Lowenstein for hosting. We're really excited to be here. To also just real quick echo Rebecca's sentiments. I mean, this has just been a stellar week. So we are so thankful to be here to talk about all things clemency. Specific to your question, Rebecca, the governor's clemency power is enshrined in the New Jersey Constitution. It is Article 5, Section 2, and it is all of 3 sentences. It's very short, and I think the brevity of it kind of lends to how powerful it can be and what a wonderful tool it can be for governors and for others who are looking to exercise this power. As far as limitations, there are 2. The governor may grant pardons and reprieves in all cases other than impeachment and treason. So especially to the extent of lawyers out there, other representatives who may want to notify potential clients or individuals, those are the limitations on the governor's on his power in this for clemency. We certainly, in our executive order, have other limitations that we have put in place, or the governor has put in place. However, as far as the constitutional limits, those are it, just impeachment and treason.
Thank you so much for that, Lee Kelsey. And really today's discussion really builds on the groundbreaking announcement, as Jeanne LoCicero mentioned, by Governor Murphy on Juneteenth, announcing the executive order, also introducing the Clemency Initiative, which integrates ACLU's Clemency Project and categorical categories. So I want to kind of shift gears and focus on the executive order for a moment. So while I'm with you, Lee Kelsey, could you provide everyone an overview of Executive Order 362 and share some insights into the establishment of the advisory board?
Sure, absolutely. So Executive Order 362, which to the extent that you want to read along while we're talking about it, it is online, nj.gov/clemency. It is posted on a hyperlink somewhere on that page. So the executive order does do the two main things. It creates the advisory board and it sets out expedited categories for consideration. And when thinking about the executive order and thinking about how the governor wanted to go about what clemency means to him and establishing his policies, clemency in the past has been about who's who and who do you know, who's been in trouble and who can speak out on your behalf. And it was extremely important to the governor to make this an equitable process and to make sure that everybody who has been touched by the criminal legal system, not just those who know people in power, but everybody has the same equal opportunities, not only to submit their application, but more importantly, to have their application reviewed and given due consideration. And so with that in mind, one of the main aspects of the executive order is to build out a clemency advisory board. These are individuals from across different spectrums on the criminal legal system who have diverse backgrounds, experiences, who are to come to the table and to give each application its due consideration with, you know, whatever lens they bring to the table. We obviously have Jessica Henry here, who is one member of the advisory board, and we have so many others. We have faith leaders, we have individuals who have been prosecutors, individuals who have been public defenders or are members of the defense bar. We have an individual who's been a judge before, faith leaders. Again, this is meant to bring diverse experiences to the table, and really the robust discussions that are had about not only an individual's case and obviously the facts underlying their circumstances, but what they've done since and what that rehabilitation looks like, or what those experiences look like and how it lends to them to meet them where they are now. And so again, it really just is meant to undergird and to really underscore the fact that the governor wants this to be an equitable process for all individuals who are really vulnerable enough to share their experiences and to ask him for this measure of forgiveness. And that really is what clemency gives to him.
Thank you for that. Do you mind, just for those that are here that may not be familiar with the expedited categories, or that may not have the EO in front of them, do you mind just going through some of the expedited cases, and just so that they can flag, you know, what categories their clients may or may not fit into? And I really just want to strongly echo something Lee Kelsey said, right? Like the environment of, you know, the governor exercising his clemency power, it really is about fairness over favor. And that's what we've been hearing. And so I really do appreciate that. And we're happy to celebrate that. So if you could just explain a few of the categories, just so people can just be aware of some of them.
Sure. I think that I can run through some of those categories. So we
Okay, thank you.
we think about this really in terms of two different paths. The first is for folks who have completed their sentence, what we'll sort of, for our purposes, shorthand as a pardon. Technically, you can receive a pardon even if you're still serving a sentence, but just to shorten the phrase a little bit, we'll call that a pardon. And for those who are still serving a sentence, which we'll call a commutation. So for pardons, you, in order to be expedited, you have to satisfy two factors, what we refer to as a time in the executive order as a time-based factor and an offense-based factor. The time-based factors are essentially a standard that you have to be 10 years post-sentence. So once you've completed your term of imprisonment, your term of parole, your term of probation or jail or whatever your sentence was, 10 years past that. There are two exceptions to that time-based requirement. One is if you were 25 or under at the time of your offense, then that shortens to 5 years. Or if you are 60 years or older at the time of application, in which case that also shortens to 5 years. Once you've satisfied one of those, we then look to an offense-based factor. The biggest category of those is going to be that you committed a nonviolent offense, which we define as anything outside of the No Early Release Act. So if it's been 10 years and is non-NERA, in other words, a nonviolent offense that doesn't fall into the No Early Release Act, you're expedited. There are a couple other factors that we take into account. So even if if you satisfy the time factor and you are not have a NERA offense or one that doesn't satisfy prong one of the offense-based factors, we'll still consider it expedited if the prosecutor's office doesn't object. We'll consider it expedited if the law or policy has changed around your offense, such that it would be treated differently today. But again, the bulk of pardons are going to fit into that first category, which is the largest group of criminal convictions in the state. Anyways, people with the nonviolent conviction. For commutations, there's no time-based factors for expedition. We look at just a series of things that the governor has decided to prioritize. The first is if the applicant is a victim of domestic or sexual violence or sex trafficking, who was convicted of a crime or offense against the perpetrator of the violence or sex trafficking, or of a crime or offense committed under the duress or coercion of such abuse. Second is if the application can establish that the applicant has an excessive trial penalty, which is based on a comparison of the sentence, a plea offer, and the sentence at trial. Third is some cases can be referred over from the conviction review unit in the Attorney General's office. Or similar to the pardons, if the applicant is seeking clemency for a conviction for a crime which is no longer lawful or unlawful rather, or if there's been a change in policy that would reflect sort of different sentencing structure today. If you said there are a couple general exemptions to the expedition criteria. One is for crimes of public corruption. Two is if you have an open pending matter. And three is if you've been convicted of a crime in another state that would otherwise not be expeditable. Those exemptions are all just for expedition. And we'll probably talk about this in a second, but anybody can still apply even if you do not satisfy the expedition requirements.
And thank you, John Butler. You actually just brought me to my next question, because I'm sure there are people sitting there thinking about, well, I have a client that doesn't meet this expedited criteria. All of this sounds great, but what are my next steps? And so how is the governor's office addressing petitions that fall outside of the expedited categories?
Yeah, one, there's no blanket rejection on any application. In other words, anybody can apply for executive clemency with the really two very specific exceptions that Lee Kelsey outlined at the beginning about the gubernatorial power. The expedition factors are really meant to do two things. One, triage what amounts to a large caseload, and two, to give some signal to applicants and to the bar about what sorts of cases the governor is particularly interested in. All cases, expedited or otherwise, still get an individualized review. Somebody in our office still reads the file, still comes to a conclusion about how to treat that case, makes a recommendation to the advisory board for a full review or a partial review of the file, or some review of the file, and then it gets reviewed. And if there's some sort of central injustice or value to executive clemency, even outside of the expedition criteria, then our office is still entertaining that. But of course, the expedition is meant to signal what sorts of cases we are, and the governor is primarily interested in.
Thank you for that, John. I think now is a great time to give you, to give everyone that's listening, not you, John, everyone that's listening, the first code. So the first code is 791643. And I will repeat that again. That is 791643. Okay. All right. So now we're moving on. So now as practitioners, we often wonder about the fate of our petitions after submission, right? This is not only a concern for us, but a concern for our clients as well. So I'm going to jump back to you. We're going to be jumping around all, throughout this whole next hour. We're just going to jump around. We're excited. We're happy today. So Lee Kelsey, can you walk us through what happens after a petition is submitted up to the board review process?
Sure, thank you. Now, as maybe some of you have seen online or have experienced through your clients, the application for submission for clemency is 12 pages long. That exponentially increases by the time it hits my desk, John's desk, and goes to the board for review. And that's due to a number of different factors. So every single application goes through and to the state parole board. And I want to flag that the state parole board in this instance is just a collection unit. They get the paperwork and they get the supplemental information, and then they pass it along. They do not weigh in on any application. They do not provide an opinion. They don't do any investigation. Their job, once that application hits their desk, is to get information from the arresting agencies, the prosecuting agencies, the Department of Corrections, the jails, basically any conviction or adjudication that has been listed in that individual's criminal case history is then, parole identifies and then seeks out the information relating to that conviction or adjudication. So if somebody has a conviction out of Toms River in Ocean County, that the state parole board will reach out to the Toms River Police Department for any arresting reports. They will reach out to the Ocean County Superior Court for the pre-sentence investigation, the JOC, any additional documents. They will reach out to the prosecutor's office to ask them for an opinion relating to the offense. And so all of those agencies are going to get somewhere between 30 to 60 days to respond back to parole. So I really want to highlight here that it takes about, I would say, at least 3 months once that application hits parole to actually go through that entire process before it can even move on to the next stage. So I really just want to highlight that, especially because there's a lot of anxiety, good anxiety, but anxiety and anticipation of like, okay, well, I submitted my application last month. What's going on? Dollars to donuts, it's still with the state parole board for at least 3 months after you submit it. So once all that information is received, parole then sends it to us, and by us, and John, me, our colleague Natasha, small but mighty team, and we will review, as John outlined, we will review if that application can be expedited in some way. And once that, if that is going to be expedited, then we make sure that all the paperwork is in order, we get everything together, and we prepare that application to be presented to the Clemency Advisory Board, and they will weigh in on that application.
Thank you so much for that, Lee Kelsey. And that's super important for practitioners to know, considering the time frame. I know everyone right now, they're very interested in submitting these petitions, and it's very important to know that at least understand the process and the timing along with it. So we're going to switch gears a little bit. Told you we're jumping around. So I'm going to you, Jessica. So can you tell us, in addition to yourself, who else comprises of the board? How is it structured? And how frequently do you convene?
Hi, thanks so much for having me, and thanks to all of you for being here. This is such an exciting initiative, and I hope that we'll get to see a lot more applications coming through. So I am one of 6 people on the board, and we have tremendously diverse backgrounds. Our chair is Justin Dews. He worked in criminal justice policy, both for Governor Murphy and for President Biden. So he's done some terrific work. Joellen Jones is a criminal defense lawyer. She also has some experience as she's had a family member who was a victim of homicide. Ed Meefsey is a former prosecutor, a former judge. He's actually the former defense lawyer too. We have Bishop Joshua Rodriguez, who is an amazing community member and faith leader, and Michael Zuckerman, who is the representative from the Attorney General's office. So we really, and he also worked in Ohio doing criminal justice policy and second look work. So it's really a diverse and committed group of people, and we meet frequently to review these petitions, and we have a lot of open discourse, really trying to sort through what is presented to us.
Thank you, Jessica. And can you tell us how often you meet and a little bit more about just how the case review process entails, like what it entails?
Yeah, so initially we meet at least once a month, and the meetings are long, very, 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 very long, hours and hours. And as the caseload increases, because again, this initiative launched in June, so there's been some time to get these applications to us. So once the real outpouring comes in, we anticipate we'll probably meet more frequently as the caseload demands. And then what we really do is we look at the applicant and we try to understand not just what happened at the time of the offense, although that's certainly part of the conversation, but also who they are now and what they're hoping to accomplish, and even what the arc is of their story from the time of the offense to the time of this petition. So one of the things that we look for, and that as practitioners who are thinking about perhaps filing applications, you should consider, we really want to hear from the applicant. We want to get some kind of narrative telling their perspective. And we look at that. We look at supportive letters. We look at documentation about what has been accomplished in the period since the offense through the current time. And we really want to understand who they are now and what the significance of this pardon or obviously commutation would be for them. And so the more that we can understand, the better we can evaluate the application.
Thank you so much, Jessica. I hope people are taking notes. I hope you're taking notes out there. This is valuable information. All right. So we're going to switch gears a little bit. So I'm jumping back to you, Lee Kelsey. So once the board makes a recommendation, what happens next?
So once the board makes the recommendation, and I want to highlight this, just because somebody may not get a unanimous vote from the board, does that mean they are knocked out of consideration? The governor takes every single aspect of what the board has said and what the board may provide as far as reasoning. He takes that into consideration. And so really our next step is to identify individuals who are going to be interviewed. And I know that interview can sometimes have a negative and again, an anxiety inducing connotation. Really what we intend to do in this interview, which I sometimes even frame as just a conversation, is to get updated information. Governor Murphy did his first act of clemency on Monday. There were 7 years worth of files that were queued up for consideration prior to those actions. So there are some people who have been, who have had their paperwork sitting with us for quite some time. And really what we present to the board at the time is what they submitted. That information can be outdated. And so really the interview process that we put together is more of an updated, tell us how things are going. And so really we just get that information. We ensure also afterwards that there are no open cases pending, whether it's in New Jersey or in another jurisdiction. And really then we prepare these files to be presented to the governor for his consideration. And he takes all aspects into consideration. He asks about jobs, he asks about education. It's really a full gamut. So it certainly does, it's not that the buck stops with the board, but things do keep moving along thereafter.
Thank you for that, Lee Kelsey. And I know, because I'm one of the attorneys. Many attorneys out there are eager to understand how best to prepare their clients for these interviews. So I'm going to jump back to you, John. So what should attorneys and clients anticipate during the interview process for pardons and commutations?
Sure. Thanks, Rebecca. And as Lee Kelsey said, they're not meant to be high stakes, high pressure situations. So that's the first thing you should know and tell your client. And we tell them as well when we speak with them. And second, that it is largely information gathering. But third, and I think this is, and it looks a little bit different too for pardons and commutations, I should say. The pardon interviews tend to be about 20 or 30 minutes. They're done by the phone. There's usually 2 of our team on the phone and then just the applicant. And it's a pretty straightforward. We usually start by saying you applied in 2018. Like, what have you been up to? How have the past 6 years been? You know, what have you been up to since then? We don't have any other information. Tell us what you're doing now. Tell us where you are now. And then go a little bit further into you know, what you know, about employment and about you know, sometimes about the criminal conduct itself, but all of it is really in service of giving applicants an opportunity to flesh out and explain things that they put in their application. Some of the applications we get are this thick and some are this thick, and it really, in both the thick ones and the thin ones, there's information that's unclear or information that isn't there. Questions that we have, questions that the board has about what exactly happened or what exactly, you know, how one piece of information might relate to another. And the interviews are also an opportunity for us to clarify some of that before taking the case to the governor. Commutations are a little bit different. So far, we've been doing those interviews in person, but I think we'll probably likely continue doing that. And it's usually Lee Kelsey and I specifically, where the pardon interviews have a wider cast of characters, and we spend, you know, quite a bit of time with each applicant, ultimately about as much time as they want, and go through in some detail their life before they were in prison, their crime, to the extent that they would like to share about it. I think it's important for them to have an opportunity to frame their offense and explain their offense in the way they see it now with hindsight, and spend a lot of time talking about their post incarceration life. What are you doing now in prison? What are you involved in? I think that conversations have so far followed a sort of pattern, but I think we also are trying to get a better sense of the people themselves. And it's worth counseling your clients to that effect. And we don't ask gotcha questions, except that for anything crucial, we ask very straightforward and very clear questions. The only gotcha questions are the ones that try to say like, but like, what do you do for fun? You know, like what, like how, or what do you watch on TV? You know, like what's a food you like? It's trying to get a better sense of the human behind the narrative and behind the file. And so again, it's not meant to be, it is stressful, and we recognize that. And so we say at every point in the process that it's not meant to be stressful, and there's very little they could say that could undermine their chances. But that, you know, there's plenty they can say that could help their chances.
All right. Thank you so much for that, John. So I think at this point, I am going to give the second code. All right. So the second code is 623-721. And I will repeat that again. That is 623-721. Okay. All right, so now we are going to switch gears. All right, so the OPD has been a key collaborator in ACLU of New Jersey's Clemency Initiative, from providing referrals to assisting with records and plea offers. And now the OPD, they're going to begin filing their own petitions on behalf of clients. So let's delve into the practical aspects of petition submission. So I'm going to go to you, Allison. So where should a practitioner begin when preparing to submit a petition on behalf of their client?
Thank you, Rebecca, and thanks for having me here today. We're very excited. This is a big priority to the public defender to work with clients on these petitions, and we are very interested in doing that and moving forward with this. In terms of where to start early. It is it's not difficult, it is a long process, and there's parts of the process that you can't really control. When you're waiting for documents, you're waiting for an opportunity to meet with your client. So the best advice I could give is that even if you're not in a position to turn your full attention to the application right away, get it rolling so that the steps can start. First thing is your client needs to work on a draft of the application. Make sure they have the application, which they should, and they should already have it, that they're working on it. As Lee Kelsey said, it's a long application, it's 12 pages. It requires them to have dates, a lot of historical information that it might take them some time to sort out. So this isn't something that you can ask them to do and the next day be ready to file. And you want them to work on it right away, because once they're finished with the draft of the application, then you want to take the opportunity to sit down with your client, do an interview, go over every answer, make sure it's complete, make sure it's as accurate as possible, give some advice if there's things that could be presented more clearly, more persuasively. That's the first thing you want to do. But then sort of simultaneously, you should be talking to your client about letters. You want them to draft their own personal letter to the governor, telling their story, requesting clemency. So you want to put this on your client's radar and have them start thinking about what they want to convey. Really advise them that they need to convey in their own voice who they were, who they are now, and why they should be granted clemency. And then there's also the letters of support. Talk to your client about whether there's any possibility of a letter of support from a victim or from a victim's family. Probably isn't going to typically be the case, but that's certainly worth pursuing a conversation. Even if the victim does not completely embrace the applicant, if maybe they at least say they think that the person has served enough time. More commonly, you're probably going to see letters from their people, especially their children, who want them home and should say that, from other family members who may be able to provide reentry support. Clients can seek letters from teachers or clergy or other prison volunteers who worked with them on the inside. There are certain rules that limit who within the DOC can submit a letter and who cannot. So that's just something that you want to be aware of. Certificates, have your clients start collecting certificates to show documentation of all the courses they've taken, of the diplomas they've earned. And so if you can kind of right off the bat, get all of these different balls in the air as early in the process as possible, then you're going to be off to a good start.
Thank you so much for that, Allison. And I wanted to really, you touched a little bit on storytelling. When you mentioned your client writing a letter to the governor. So I wanted to know, can you highlight the role of storytelling in crafting an impactful petition?
Sure. I mean, as with most of the advocacy that we do as criminal defense attorneys, the storytelling is critical. And from my perspective, I think a compelling petition is going to be one that really can humanize the person and can allow the board and the governor's office to really understand the person's situation and who the person is. And so I think storytelling in this context becomes important in two respects. It's you telling your client's story in a narrative, and it's your client telling their own story in their letter to the governor. And I think you might at first think that storytelling would be difficult in a clemency petition because they're typically serious crimes that resulted in long prison sentences. But the crime isn't the story. The crime is the background, and you certainly have to address the crime and be forthright in discussing it in the narrative. But the story that you're really telling is the person's story. And in that sense, the storytelling is really the whole point. It's the heart and it's the soul of these petitions, because you need to convey who the applicant is, how they got there, their story of personal redemption or of growth and resilience, of overcoming obstacles or of achieving goals that they set in prison. So for the narrative that you write for your client, you need to explain how your client fits into one of the expedited categories. That obviously you have to do that if they do. But then beyond that, it really is telling a story. You're not relitigating the case. You're telling the story of who your client is now and the process and journey that got them there.
And thank you so much for sharing that and highlighting that. And I think this is where practitioners might relish in, and they might really enjoy this part, because that's essentially what we do, right? And it's super, super important to make sure that we tell them accurately and that they're super impactful. So I want to talk, so we're talking about all the positive things, right? And so I do want to address that there are some challenges. So what challenges might practitioners encounter when filing petitions, and how can they navigate those obstacles, Allison?
Sure. I think I describe them as falling into two categories, what I would call administrative type challenges and substantive type challenges. With administrative being the challenges associated with gathering all of the documents and the supporting information. And then the more substantive being the challenges associated with presenting the most compelling petition that you can. In terms of administration, it's the record gathering. Some of these are old cases, and you want to try to get everything you can. You want the judgment of conviction, you want the pre-sentence report, you want to have as much information as you can, old appellate division opinions. And then one of the biggest administrative challenges is that if the client had a trial tax or is a domestic violence survivor, you want to find proof of that. So you're looking for a pretrial memo, if there was one, so that you can see the plea offer. Or you're looking for transcripts that reflect the plea offer or document the abuse. Maybe there was an expert report at trial documenting the abuse. So you just want to dig deep and find these documents, which can be time consuming. Ways that you can navigate that. If the client has their file, they're often a good source for some of these documents. E-courts, if it's not a really old case, a lot of times these cases are going to predate e-courts. Westlaw Lexis for the opinions. If it was a prior OPD client, we may be able to help you get some of the file. So you can reach out to me if you're having a specific issue and there's something that you need, and I can try to help. In terms of substantive, I think where you can and where it lends itself, you really want to have a theme, whether it's personal transformation or forgiveness or mercy, or whatever your client's story sort of naturally lends itself to. And so it can be challenging to figure out what that is, what it should be. And then I think even more challenging is how you fit it all together, because I think one of the most compelling things to do is to create an application where that theme is running through it, right? So that your client's narrative talks about that, your narrative talks about that, the letters support that. So it can take some time to sort of sort through, really think through what you're trying to accomplish in the application.
Thank you so much for that, Allison. I just wanted to add just a little bit, just from my experience too, just when you're starting off, you're thinking about filing a petition, definitely just get on getting those records as soon as possible. And also, because there are so many factors and so many things at play here, if you have family members that are ready and willing and able to help, just have them write the letters of support right then and there, right? And you can say, give them a deadline too. That is helpful when people have deadlines, right? And then also what I do is I also give people some guidance, right? Because sometimes, we are very busy, we're living our lives, we love someone, we support them, but then who's really sitting there thinking about how much who's really ready to articulate that, right? And put it in a letter. Sometimes it takes time to do that. And sometimes people don't know where to start. And so give them some time to get their thoughts together. Sometimes I even give some guidelines, just to say, just tell me about the relationship you had, share some memories, what will it mean to you to have this person back home? So give them something to really focus on, because it's a lot. It is overwhelming. It's exciting. And sometimes, those things don't automatically just come to everyone. So just keep that in mind when you're thinking about starting the petition. If you can get everyone just working on things as soon as possible, that would be honestly one of the best practices. So I am going to give you your third code. We're just flying through. So I guess we're gonna have a lot of questions. I do have another question for the panelists, but we do have a Q&A towards the end, which is quickly approaching. What's happening? We have to have a robust discussion soon. So code number 3 is 720-846. Again, that's 720-846. Now, I do have a question that I would like every single panelist to answer, and we can jump in. It doesn't matter what the order is. But the question is, what advice would you offer to those preparing and submitting petitions, including pro se applicants? So I know we're here. I know this is for our audience are mainly lawyers, but the reality is that many people are submitting their own petitions. They're submitting pro se applicants. So I would like you to include that in the advice that you would like to share. So I can call on anyone, or if anyone wants to jump in, please go ahead.
I'll start.
Okay.
Do not think that your client should not submit an application because they may have many convictions in the past, because their cases are more recent. We are willing and able to process those applications too. I think especially for pro se applicants, do not think that you aren't qualified in some way. We read every single application. We want to hear your story. We want to give the opportunities that are available to you. So please do not hold back from submitting an application.
Thank you, Lee Kelsey. John, do you want to go next?
Yeah, I mean, I have a list. Lee Kelsey and
great.
I, between the two of us, have read, I think, hundreds of, at least hundreds of files at this point and thousands of pages of applications. And so we have a certain sense of the body of work. And some of that's concrete and some of that's more abstract. I think more abstractly, I had a law professor who used to always say that like your strongest argument is only as like it needs to be stronger than your opponent's strongest argument, basically. And I think that's true in this case too, that you can't shy away from negative facts. And in fact, like it is very helpful if you, and in fact, probably necessary that you steer into negative facts, and you don't have to make your narrative about that, but use the application as an opportunity to explain the worst parts of the application or the vulnerabilities of the application, because otherwise we are left to fill in the empty space with our own thoughts or our own reservations, and that can be really broad or really like obvious and particularly in the commutation cases or in a homicide commutation case. But I think it's true in almost every pardon we have too, where it's just, we ask and the board asks, and Jessica can talk about this too, like, what is that like third-degree aggravated assault from 1985? Like we have no information about it. What was it? And it's not to say that if we don't know, we won't grant. It's just those are the sorts of questions that we're asking, and being able to answer some of those in the application is helpful, and will often, I think more often than not, allay fears rather than create more. So that's one. Two, I say this to pro se applicants especially, but you don't need a lawyer to fill out your application, but it helps to have an editor or somebody who reads it and tells you what's strong or what is very clear, what is not clear, word this a little bit differently. And I think that probably goes for lawyers too in general. I always have LoCicero read anything I write, and maybe I won't say vice versa, but maybe vice versa, just to get somebody else to make sure that I'm being really cohesive and clear. Three, it's helpful to roadmap if you're filing and creating applications for somebody else, especially in some of these more complicated ones. Again, if it's a short, like relatively easy 1 or 2 offense pardon application, that's a little bit less, that's a little bit easier to roadmap. And I'll say the ACLU is very good at this. In their application submissions, there's a table of contents, and there's like, and not that it needs to have a table of contents, but it's sometimes unclear if we get an application that's like this, that just has a bunch of papers, and it's sometimes unclear like how one paper relates to the other, or where a thing comes from. It's sometimes, especially if what you've just done is take the a particular part of a trial transcript or something and used it as evidence, it's sometimes unclear like how does this relate to the rest, or where is it coming from, or why is it here? And being able to just think through, if you're coming at this fresh and just somebody just slapped this file down in front of you, how like will the person reading this be able to understand what's going on here? And Allison's point about narrative and making sure it's a coherent thread throughout, really, I would put that advice in the same column as that, and do that exercise together and say, make sure it's clear. It's sort of like admissions or something at college, where we have thousands of these things, and we need to I wish we could say quickly, it's actually quite slow, but the easier and clearer you can make it for those of us who are reading to sort of get to what the points are and what the important parts are, the better for your clients. And the last thing I'll say, at least on this, and it's not even exactly responsive to your question, Rebecca, but I think it's important for the bar to know, the bar that's interested in this. I alluded to this at the beginning, but my contention, and somebody can fact check me, is that the largest group of criminal convictions in the state of New Jersey are non-NERA offenses. They're just a huge group of people out there with criminal convictions that are non-NERA and pass their sentence. Maybe not 10 years. I think plenty of people are 10 years past their sentence too, but 8 years, 9 years, 7 years, and non-NERA, non-violent offenses. And we just don't have nearly enough pardon applications to reflect that fact. And so a lot of the bar is rightfully, very, very, very rightfully focused on the commutations, because it's, as Rebecca can say, and LoCicero and I, and everybody on this call who have spoken with the women who are commuted, and as Rebecca is very raw right now, as they were just released, those are crucially and vitally and monumentally and transformatively important. But also, because there's so much attention on those, there's this whole universe of other cases that are fairly easy to get through the system and fairly easy for us to review and are like really squarely in line with the executive order. And like, you know, nobody's filing those, or not enough people are filing those. So as members of the bar and as lawyers thinking about that, thinking about how you can help with generating some of that as well, I think would be time well spent. Thank you for indulging my extra minutes, Rebecca.
No, thank you for that, John. We love it. Jessica, do you want to go next?
So one of the things I think that is really helpful, particularly for pro se applicants or for people who maybe are going to advise folks on the pardons while you're focusing on your commutation cases, are letters. So I think sometimes we get really thin applications from someone who just sort of says, I'd like a pardon because it's really impacting me. And it just doesn't add a lot of color. And I think for those folks who have older convictions that they haven't necessarily shared with the people in their lives today, that's actually really important to put in the application to explain away an absence of letters, because we do look for those to provide context. They're not required, they're not mandatory, but they do help us fill out who the person is. So I would encourage people to think creatively about who could write on their behalf. I do think that's really helpful. And I was going to echo what John's last point was. We are really open and interested in providing pardons. We know the collateral consequences of criminal convictions can be devastating. And there are lots of people who come from over-policed communities who may have convictions that are ripe for pardoning. And so we do encourage people to think creatively about finding and identifying those people and submitting those applications. And then I think just the final thing to say is that because of the timeline, because of the upfront work that needs to go in, the sooner these applications can get filed, the better your client will be. I would not wait long to start this process. And I wouldn't plan on filing December 31 when you know December 31 of 25, when you know the governor's leaving in January. That just won't be enough time to do the pre-clearance work that the governor's office and the Department of Parole and everyone else is engaged in.
Thank you for that, Jessica. Allison?
Sure. I'm just going to add that I think there's really no substitute for authenticity. And so whether you're preparing the petition for an applicant or whether an applicant's submitting pro se, I would say for the pro se applicant, just tell it how it is. I think, you know, as we're hearing, the governor's office and the board are reading hundreds of thousand applications. So I'm going to go out on a limb and say that I'm sure that they are pretty adept at ascertaining what comes from the heart and what maybe is less genuine. So if you're preparing for a client, I think the way you get there is to spend the time talking with your client so that you can help tell that genuine, authentic story. And I think that's going to be a lot easier to do if you take the time to build a rapport, ask maybe some hard questions of your client so that you can get a little below the surface and hopefully write the most compelling narrative possible.
Thank you, Allison. Well, that concludes our panel discussion, but we do have a question and answer section, which I would like to dive into right now. We have about 20 minutes to answer some questions, so I think that's perfect timing. So I do have some questions. So the first one is, Allison mentioned filing things like pre-sentence reports. Often these include inaccurate or unflattering narratives that track with the prosecutor's view of the defendant. Should advocates include these even when the narratives contained in them are problematic and incomplete? And I see some head nods, so
yes.
Yes.
We'll have access to it. If you have access to it, we'll have access to it. And it's better, this goes to my point, it's better if you present it, and then if there's context that you can provide around it, that's better for you and for your client than if you don't submit it. We'll like, we get the pre-sentence reports from parole requests that as part of the packet, and so we end up usually with just 2 or 3 copies of the same pre-sentence report in each file. And so I wouldn't try to in general, as a general rule, I would err on the side of inclusion rather than exclusion, because we're going to want to fully vet this, and we are, and Jessica said this really well, like we really are. This is an exercise in mercy. We're not going through it to look for things to knock somebody out. We're looking for things to try to be inclusive. The governor's very excited about this. He wants people who are truly deserving of this opportunity to have full advantage of it. And it's actually those kinds of things that will trip somebody up. Not that it's like the bar, right? Where they're like, you can have a criminal conviction, just don't lie about it, right? Or you can have whatever thing, just don't lie about it. I think that's the similar principles at work here. Okay, what would you add?
I think you said that perfectly. We're going to read it. It's usually in the packet anyway, and it really gives a fuller picture. And I think sometimes, even if they're inaccurate, or even if they are maybe not how your own client or that person would explain the situation, it also helps show a level of growth and the trajectory of the person's life. And it's just important to kind of own up to that, because as John has mentioned, as Jessica has mentioned, as Allison has mentioned, otherwise we're going to be left with these gaps that we don't know what to do with. And it's really just important to just show face to it and acknowledge it, and then, again, show that arc that somebody has traveled on.
Yeah. Oh, yes. Go ahead, Jessica.
Just what, the thing about the bad fact or the bad offense, you can't change it. It happened. And so owning it and kind of explaining the arc of the story around what happened and who you've become since is really important, because we can't make a decision based on a static thing, and we can't hide from it. So I would add that, just be mindful. It's really about the arc. It's the journey that's important.
Absolutely. Thank you. All right. So I have another question. So if someone who was previously ineligible for an expungement, but has now received a pardon, does that either, one, make them eligible for an expungement, or two, negate the necessity of an expungement? And this is coming from an attorney where one of their clients was pardoned this week. Woohoo! Congrats to you and your client. So now they're trying to think about expungement. So is anyone able to answer that?
Sure, I can. The answer is an unfortunate, it depends. The reality of the situation is that the pardon, let me slow myself down a little bit. When somebody receives a pardon, they will also be receiving a certificate that shows exactly what they have been pardoned for, the date of arrest, the offenses, the conviction, etc. It is signed by the governor, has a gold seal on it. It's a beautiful piece of paper. They will also have their criminal case history updated. Typically, what we found is that there is some level of demarcation indicating that they have been pardoned. It may also show up as a dismissal. What we have been advising people, and again, I wouldn't say this is legal advice, but what we have been saying to people is, we do not believe that there would be a harm in trying to receive an expungement. You have additional new information relating to the offense for which you are seeking an expungement. We cannot guarantee anything. There is nothing set in stone about how the courts have to treat a pardon. However, it's new information. So really, I think it's really a judgment call about if it is necessary. Technically, the offense is still on your criminal record. It will still it'll still show up, and obviously with an expungement, it does not. So I think that's really kind of a balancing act that the individual has to have for themselves, and probably weigh the options of well, who's actually doing this criminal history check and what's going to be enough for that purpose.
Thank you. All right, I'm going to keep going to our next question. We have a couple more. All right, so the next one is, do you only make clemency determinations based on one current offense, or do you look at an applicant's history of offenses if there were any prior offenses?
Jessica, why don't you talk a little bit about how the board thinks about like one versus many offenses?
We look at all of them. We look at all of the convictions. We look at the dates of those convictions. Sometimes you can see sort of from the dates of conviction that there was a period of time where that person was clearly experiencing something that led to a space of criminal behavior. It's a little more confusing for us when perhaps there's a number of convictions and then a big gap and then a conviction again. Because what we're really looking for is that arc, that story. And so again, we're going to, the information is out there. And so I think to the extent there's a newer conviction and older convictions, it's important just to explain and contextualize. The more information we have, the better we can use our discretion in those applications. It's not like we won't know about a new case. So it's easier for us if you would just explain it, because then otherwise we kind of, what happened here? What do we think happened? How does this impact us? What does that mean? The more you can tell us, the less guessing we have to do. And the more you can frame it in a compelling way, the better it would be for your client.
Yes. And I mean, I'm really, before I go on to the next question, really just sensing a theme, right? Like we are embracing bad facts. We're embracing what actually happened, right? We're embracing our clients' full stories, right? And sometimes it may not be pretty. We know that. We know that sometimes, there could be facts that where, at the time, they had a very different mentality, and that's worth explaining, right? It's worth explaining where they were at the time, mentally at the time when they committed the crime, right? As opposed to who they are now, what tools they have now, what skills they have now, so that this doesn't happen again, right? So it's all about that transformation. It's all about that journey, and it's all about embracing it. Right? This is, it's not the court of law, so it's different. So we're really embracing our client's journey and their transformation. And so I have some more questions. So the next one is, given the timeline of the governor's term ending, is there a point in 2025 in which an application that is filed is unlikely to get before the governor's desk before his departure? I think we can all say, do not file it on December 31st of 2025. But just to add some more to that, does anyone want to take that?
Sure. Yes, there is. Well, there's certainly a deadline, in the sense that we will at some point no longer be in office. I think the best advice we can give is probably to try to get any of your petitions in by this spring, or early summer. Every petition's a little bit different. Every petition has a little bit of a different timeline. A particularly complex case takes more time. A very simple case takes less time. The other variables are that we're hiring some people, we're getting more help here. Our processes are getting more streamlined as we're doing more of these. And so there's like the length of time that a complex or a simple file takes to get all the way through the ecosystem might shrink. And so all of those things might mean that a petition filed in September of next year could be reviewed and presented to the governor in time for a decision before he leaves office. But I wouldn't risk it. I would say that, if you are working on a petition, if you know somebody that's working on a petition, if you are trying to find clients to work on a petition, try to aim for spring or early summer at the latest.
Thank you for that, John. All right, so the questions are rolling in. People are getting excited. So we have some more. This is not so much a question, but a request. Can you comment on the public misconduct convictions?
Sure. So again, as I think I alluded to in some of my statements early on, the whole point of this process is to ensure that it's not individuals who have favor or know someone who knows someone that received these opportunities. And so in order to ensure that that policy underlines everything, we have explicitly stated that even if you qualify for some other reason for expedited consideration, if a charge of official misconduct is somehow packaged within the conviction that would otherwise make you eligible for that expedition, we're actually just not going to expedite you. Again, you may have the individualized consideration in due time. It's not our intention to completely say that you are disqualified. That is just one of the cases where the governor has identified that because of the actions and the policies that he's trying to put forward, that is in opposition with public misconduct charges or official misconduct charges. So we are not going to expedite cases with those convictions.
Thank you for that, Lee Kelsey. So we are going to try to get through most of these questions. So I'm gonna just keep going until we run out of time. See, before we were doing well, and now look, we're running out of time. So this one is for you, John. So they're saying, John, you mentioned a table of contents for excerpted transcripts. My question is, should we be trimming down transcripts and other exhibits to just be hits or relevant parts? Or is it better to simply present the entire unedited documents as evidence and just properly cite them in a table of contents or in a petition footnotes?
Yeah, I'm maybe going to give like the most annoying answer for somebody, or maybe the most annoying answer would be like, it depends. The second most annoying answer is the one that's going to be the most work, which is I think it's helpful to have the full I mean, the question went away, but maybe this was what the questioner was presenting in the second option, which is basically spotlight whatever is relevant to help your client, but it's helpful for us to see the full context in the back. And honestly, it's helpful because like it often, like more often than not, it ends up helping your client's case to be able to say, you know, this was to be able to verify and say clearly, like, I read the transcript and this is presented earnestly, that this is whatever the point you're trying to make. You know, I read the whole thing and the thing the lawyer is saying about the thing is true. That's the sentence you want us to be able to say, and the board be able to think, and the governor to be able to sort of have in his mind. And so saying this is the part that matters and here's the rest if you want to read it, I think is the best way to go.
Thank you, John. All right, so there are more. Will there be any notification to people whom the board has decided not to recommend?
There has not been any notification yet. We are discussing that internally. At this point, all cases that have been sent to the governor's office are still live, except I suppose for the ones that have been granted, which are granted and closed. None have been rejected and closed. And we're not sure what sort of notification we might make. Like, Kelsey, you want to add more?
I just want to say that the opportunity to receive an act of clemency from the governor is going to be open until he leaves office in January of 2026. So I think that is part of the reason why we are not sending out denials. Additionally, we receive supplemental information from individuals all the time, and that can be helpful in the process. And so we don't want to preemptively make a decision before we get all the information.
Okay, thank you. And there's another question. Is there a process for someone who filed an application for executive clemency in 2020 and now believes they qualify for expedited review? You might have touched on this a little bit when you were just talking about supplementing. So,
sure. So
yeah.
If there was an application in 2020, we already have it. We have become extremely adept with spreadsheets and Microsoft Access and Excel and figuring out, you know, just going through and looking at the files. If there is an individual who believes that they should be expedited, certainly that can be something that's flagged for us. You can send a letter through parole or through clemency at nj.gov, which is the clemency email that we use to respond to attorneys or stakeholders or applicants that have questions. We believe we've gone through and have been able to identify, certainly, especially for pardons, those are date and offense specific. Those are easy to kind of triage through a spreadsheet. We believe we've identified all the expedited materials, expedited cases, but to the extent that there is something or that more information keeps coming in, obviously we are open to being pinged on certain cases, and we'll always review the additional information.
I just add it is particularly like commutations that were filed before the executive order are tougher to identify as being expeditable, or I'll say potentially impossible to identify as being expeditable, despite maybe being expeditable. So for commutation applications in particular, it might make sense to submit a supplement if you believe your application is expeditable, but you did not make that clear in 2020 when you applied. The second thing I'll add is that the announcement that the governor made on Monday does not include it. That does not reflect all of the expeditable pardons that we have received, reviewed, or will provide an announcement for. So an application from 2020 may have been expedited, but not acted upon yet, but has been, maybe was expedited, and you wouldn't know necessarily.
Thank you for that clarification too. So we only have time for one more question. So the last question I will ask is, how is the applicant who maintains innocence looked at in this process?
That is a difficult question because we understand, and I think a lot of our conversations have been like, acknowledge the bad facts, acknowledge the bad facts. And really, if there's an assertion of innocence that kind of cuts both ways, I guess, we take it into consideration. It's another piece of information to review in light of everything else in the application. Again, we're talking about narration, and we're talking about stories, and we're talking about themes and the client's point of view. That is the client's point of view. And I think, again, to the extent that there's a level of comfort or discomfort in going against what the conviction otherwise says, I mean, it's just, again, it's just another aspect, it's another layer. I would say maybe somebody else should lend their ear to this one too, because it's really important.
Yes. And I will just add to that, your client's truth is your client's truth, right? You cannot change that. And what's important is that your client, yes, they're saying they're innocent, but there's still a journey. There's still a transformation. There's still a story to be told, right? So I come across clients that have maintained their innocence, and sometimes they're just like, I did not do this, but I know back then I should not have been hanging around with these type of people, or, I shouldn't have been in this crowd. I shouldn't have, been engaging in things like this. So it really depends. It's going to vary for every single client. And like, regardless of them maintaining their innocence or not, they still have a story, and that is the story that needs to be told. So I think on that note, we will end here because it is 1:45. And I just want to thank you all for joining us. And thank you to our esteemed panel for engaging in this conversation. And I just want to remind everyone, please submit your CLE surveys. And the link should be down there for the survey. So thank you all. Thank you. Have a wonderful day. And I'm smiling because my clients are released, and I hope that you get those petitions in. I hope you learned a lot through this process and throughout this event. Thank you very much. Take care, everyone.